Yeah, that's so you're interested in the question? No,
Okay, good morning. I'm here for hearing another motion for further temporary order and motion to compel. So I'll start by asking Mr. Conacher, what's your client asking for?
Essentially, Your Honor, it's twofold. My client is asking for the shall leave us in the order to produce information and documents in response to our motion to compel discovery. Further, Your Honor, with respect to the motion to refer to temporary order, he is essentially asking for later time with the children. She's asking for the court to appoint some therapists for the children, and we're asking the court to consider modifying the current possession schedule that the parties are currently doing. Attorney's fees in connection with both motions today.
I very specifically object to most of that because Rhonda Bell has not come before the court properly. She has no standing to do a modification, as this is a agreed judgment, and as an agreed judgment, she knew full well what the contract terms were, and she never discussed anything with me in regard to modification. Lastly, because the standing hasn't been proven, and from the very beginning I started with a conditional acceptance of proof of claim, and that's a discovery request, and Conacher and Rhonda Doe did never produced a proof of claim of any type. They've been in default from the very beginning because on the first hearing they should have provided proof of claim, nature, and cause as to why this lawsuit is happening, and there was never a conference with me in regard to any of this sort of modification. So from the very beginning, I still don't know what the nature, the cause, or the legal intent of the court is, or what the modification is about.
Okay, so I'm going to give you all 40 minutes each. And in that 40 minutes, you can ask any questions of your witnesses, put your own testimony on, make any other arguments that you want to make. If one side runs out of time, they can't put any more testimony on, ask any other question, make any other arguments. If the other side has short time limit and one runs out of time, that side is willing until they also run out of time. I do have a 10:30 study, so that's kind of the boundary for my time today. So, yes, sir.
I've put in paperwork in regard to the testimony of the attorney because he has no first-hand knowledge and he does not know what's going on with this case specifically because, again, he doesn't have any first-hand knowledge. When he's speaking, he's basically testifying. So if the plaintiff wants to address me, then I would require her to do so. If the attorney is the one doing the speaking, then that's hearsay, and he has no standing to be the one speaking.
Well, to the extent that Mr. Conacher was making statements regarding the case, they are not evidence. They are essentially arguments that are not evidence. Just asking the court to do something. He can ask questions. He can put testimony. If he's asking for attorney fees, he can put testimony on regarding his attorney fees only. But that's the limit of testimony that he can do.
One final thing, in the divorce decree as a contract on page 27, it speaks specifically about attorney's fees. And one thing that Rhonda Doe and I agreed to was the fact that any further litigation in this case has to be covered by the person that ensued the litigation. In other words, every one of us pays for our own attorneys based on the final decree of divorce contract that she acknowledges that she has read and she agreed that she understands. And as Mr. Conacher tries to intercede with attorney's fees and being paid by me, that's complete breach of contract that Rhonda Doe has with me. and that she agreed to as terms and conditions of the court as well. So it's an order, and as far as attorney's fees go on this, they are covered by the individual that ensues the litigation.
I'll certainly consider that argument. It's like a lot of the other arguments I'm going to hear today. I just have to hear the evidence arguments so I can make rules. So at this point in time, I've sworn in the parties before. I'm not going to repeat that again, but everybody remains on the road. Ms. Zilka, I assume you're going to testify?
I think so, Your Honor. I have a subpoena.
Okay, please raise your right hand. You solemnly swear to affirm the evidence caused now before is the truth and nothing but the truth.
Yes, I do.
All right, thank you. Okay, Mr. Conker, you filed the motion. Do you wish to make an opening argument?
No, I'll waive opening, Your Honor. I am going to start with Ms. Roca, but I would go ahead and invoke the rule at this point. If Mr. Oliva had any of the witnesses next to him, behind him, that he intends to call today.
Okay, Mr. Davis, do you have any other witnesses that are there with you today?
They're just observers and just witnessing the hearing itself. They're not going to be actually testifying. Other than if this is based on child preference, my sons, both of them are here present, and both of them are willing to talk to the officer who's running this, so that we can clarify whether their preference is one or the other. I don't see a point in badgering or defamation of character trait from the opposing plaintiff if the children are here and they're older than 12 and they can testify for themselves what preference there is. I see no point into all the other evidentiary or defamation related testimony that is going to be offered up.
Okay.
Your Honor, if Mr. Olivas is saying that the children are present, I'm just asking that we make sure the children are not actually physically in the room where they can hear this proceeding.
Yeah, Mr. Olivas, I'll make sure their voices are heard in one way or the other. Can you allow them to leave the room so they can't hear the testimony?
They're not in the room, they're in the living room on the other side, so whenever that is happening or whenever you want them to step in, I will have them be brought in.
Okay, thank you, sir. Okay, so, Mr. Conacher, if you'd like to call your first witness.
Thank you. Your Honor, I'll go ahead and call Ms. Silva.
Okay, go ahead.
Ms. Silva, can you hear me?
Yes, I can.
Thank you for being here today, ma'am. Please state your full name for the court.
It's Diane Zilka.
And what is your place of employment?
I work for Dallas County Family Court Services.
How long have you worked for Dallas County Court Services?
22 years.
And were you court ordered to do a child custody evaluation in this case?
Yes, sir.
How long have you been doing child custody evaluations?
For the whole time of my employment, for 22 years.
Now, in this case, do you recall when you started this present child custody evaluation?
The original interview date was supposed to be March the 2nd of 2021.
And is the child custody evaluation still ongoing at this point?
Yes, sir.
Okay. And are you familiar with my client, Ms. Robinson?
Yes, I am.
Has she been actively participating in the child custody evaluation?
Yes, she is.
And are you familiar with Mr. Olivas?
Yes, 2 of us are attending.
Now, did he attend his appointment for Zoom orientation on March the 2nd of 2021?
No, I did not.
And did Mr. Olivas indicate whether he would participate in the child custody evaluation or not?
He did. We had a few emails back and forth, and he said that he was not going to.
Okay. Did he indicate anything with respect to the children, the subject of this case, and their participation in the child custody evaluation?
He said a few things. He said that he did not want them to participate in the study. He had some things to say about the child interview that was done previously.
Okay.
I have a quick objection based on the testimony being given in regard to the reasons why I talked to Ms. Diane and I let her know exactly what I was asking for, which was a verified court order.
Your Honor, he's testifying at this point. I'm going to object.
Just state what's your objection, Mr. Lee?
The questions that the attorney is doing are leading, and they're not. They're leading the witness, basically.
Overruled at this point.
Okay. May I ma'am, did you file a status report with this court? Was that on April 1st of this year or no?
I believe so.
Your Honor, I'm going to ask the court to take position those if it's filed, including the report that was filed by Zilka. The court will take judicial notice of the case file. Ma'am, was Ms. Rhonda Doe scheduled to do anything on April the 28th of this year?
Yes, she was scheduled for an in-person observation appointment for her and her children and her household members.
And were there any difficulties in doing what you just said she was supposed to do on April the 28th?
Well, when she came, she only had one child with her.
Do you recall which child that was?
It was Ivan.
Okay. And did you learn what was going on with the other child, Ruben?
Mom said that she couldn't get him from dad for that week of possession included by an observation.
Okay. Were there any difficulties that you actually strike that? According to your report, is a one-sided evaluation currently underway?
Yes.
Okay. Will you be able to make recommendations as to conservatorship or access for either child currently?
No.
And why is that now?
Because I've only heard one point of view. I haven't had an opportunity to evaluate the father.
Okay. And will you be able to make recommendations for the services for Ruben if Ruben is unable to be observed with my client, Ms. Rhonda Doe?
No.
Okay. And will you be able to make any recommendations for those issues if Mr. Olivas continues to not participate in the child custody evaluation?
Not for Ruben, no.
Okay. Now, in order to press forward and complete the child custody evaluation, what would you need this court to order with respect to the children the subject of this case?
I mean, I'm not in the habit of telling the court what to do.
But what do you need?
What I need is I need both kids to participate. I would love it if Mr. Joseph would also participate. I can't force him to do that.
Is there anything else you feel like this court should know that would help you in completing the child custody evaluation, or no?
Nothing really comes to mind.
Okay. No further questions, Your Honor. I'll pass the witness.
Okay, Mr. Davis, do you have any questions for her?
Yes, I do. I have a couple of questions. Ms. Diane, did I, in our correspondence of email, let you know that my concerns for my son's well-being in regard to Rhonda Doe living with a registered sex offender that regularly visits the home, was that known, to be known to you in our correspondence?
You said that in your email, yes.
Did I also request for you to provide me with a Judge Kim Cooks, which is assigned the case itself, or assigned official certified order of the court for a child custody evaluation to be done?
I'm not really sure what you were asking for.
I'm going to make the compound question, Your Honor.
Overall,
Your email was a little bit confusing to me, so I never really was very clear about what you were asking.
Well, very simply put, I requested for a copy of the order of the court for the child custody evaluation as per the standards of the family code, where everything that is being evaluated and the reasons why and the depth of what needs to be answered has to be in that order. So I was requiring that order or a copy of, and I was never given it by you.
Yeah, was there a question in there?
make sure the question is still in.
Did I request an order, an official order signed by the court and properly issued from you, Ms. Diana?
So we gave you a copy of the order for this evaluation, and then you were asking for something else. And I was never clear about exactly what else you needed.
What is the standard of process for you to verify a court order, whether it's coming from a judicial officer or if it's a procedural standard? What do you use to decipher whether it's an order officially from the court?
So that's something that happens before the case is assigned to me, so my supervisor would do that. Basically, all that we require is a county court services order that is signed by the court.
Did I believe I requested from you also, whoever could give me that copy or a reference to whoever could give me that order. You say that you don't have it. Why didn't you give me the reference to who I could speak to so that I could get that order from them?
We emailed you a copy of the order a few times.
Was that the officially signed by the clerk officiating that it was a court order, or was that signed by simply the associate judge? Whose signature was on it?
I'm sorry.
Whose signature was on there?
It's signed by the associate judge.
Okay. Is that an official court order from your standards?
Yes.
I would defer at this point to the fact that, as per the standards of the court, the court order for a custody evaluation needs to be on some sort of basis. Well, I don't have any further questions for you, Ms. Diane. I believe that I required everything that I asked for from you, and I didn't get it, so I don't have any further questions for you.
Mr. Confer, do you have any other questions for her?
No questions from the council. Thank you for your time, Mayor.
And you all, are you all in agreement for letting her get back to her order?
Yes, sir.
Yes.
Mr. Lee? Okay, thank you, Ms. Duffy, your excuse. Okay, Mr. Confer, call your next witness.
Sir, I'd like to go ahead and address the motion to compel discovery and get that out of the way before I proceed with the motion for further temporary orders, if that would be okay.
Well, I mean, we're in the middle of witnesses right now, so you can call your next witness. If you want to make argument, you can wait till the end to do that.
I'll wait till the end to make argument on that. And at the time run, I'm gonna go ahead and move to get P1, the summary request for relief.
Any objections to P1 as a summary?
Yes, I object because I still don't know the nature. The nature and cause to this lawsuit is still not known to me, and jurisdiction has been completely challenged, and nobody has proven jurisdiction on the record or made a proper appearance before the court. So I can't agree to that admission to evidence.
Okay, the P1 is admitted into evidence as a summary only, and it's not taken as proof of any facts asserted therein.
Your Honor, at the time, I'll go ahead and call my client, Rhonda Doe, as my first witness.
Okay.
Ms. Doe, can you hear me? Yes, good morning, ma'am. Ma'am, do you previously recall attending a hearing in this matter on December 3rd of 2020?
Yes.
And at that time, were you and Mr. Olivas ordered to refrain from discussing the litigation with the children?
Yes.
Have you discussed the litigation with the children?
No.
Objection. That's a false statement. The litigation started because she said child preference was part of the motion. Therefore, she had to have talked to the child before she even began the petition. That's a.
The court considers truth as to weight and not admissibility.
Okay. Ma'am, has Mr. Olivas, to the best of your knowledge, discussed the litigation with the children?
Yes.
Okay. Did you record a conversation between you and Mr. Olivas earlier this year?
Yes.
And when was that, if you recall?
On January 1st of 2021.
Now, is that recording contained and was the marked for identification as P4?
Objection. Relevance.
I don't know, I haven't heard it. So I'll take that objection under advisement.
Ma'am, and the recording is marked for identification as P4. Whose voices are contained on that recording?
Myself, Georgia Olivas, and the children.
Now, is that recording an authentic and correct recording of the conversation that took place on January 1st of 2021?
Yes.
Was this conversation that took place in that recording made voluntarily and in good faith without any inducement?
Yes.
Have any alterations the entirety of the recording that you made on January 1st of 2021.
Yes.
Your Honor, at this time, I'm going to move to the T4 in evidence.
Mr. Levis has objected as to relevance, so I'll have to hear it in order to make that ruling to determine if it's relevant to the suit or not.
May I publish the report, Your Honor?
Yes.
Okay. May I please, has screen sharing been enabled, Your Honor?
Yes.
I'm going to go to share my screen, Your Honor. Actually, that's initial audio.
Objection. Why is it starting at 4 minutes and not at the beginning?
Your Honor, to play a 38-minute recording would take up all of the time I have used.
Then I object for completion. I mean, it's not a full, what's the point?
You can require the playing of the entire thing, Mr. Levis. Part of it on your time, part of it on Mr. Conover.
Well, based on relevance, first of all, I'd like to know what the case is about. I still don't know nature and cause, so I don't know if the audio recording is even relevant. See, he hasn't disclosed nature and cause, or proven that he has standing to even sue. So I can't say whether it's relevant. I don't know. He hasn't disclosed why this lawsuit happened.
Sure, that's a relevant objection, Your Honor. I'm limited in the time I can play the entirety of the recording. I'm going to play relevant portions.
Objection. I mean, if I don't even know what the nature and cause is, how can we know if it's relevant?
You can play the recording at this point.
Thank you, Your Honor.
They don't want to go with you. They're like when I went to go pick them up with you and the cops and the civil matter, and if they don't want to go, they don't have to. That same thing applies here.
But that time you hadn't picked him up in a long time. You didn't know. I know this is a big violation.
If you want to know, if you want to do it, call the cops. Go ahead and call them. The cops are going to ask you two questions. Are the boys good? I'm going to turn them over to you and look at it. And they're going to
But you're talking to the police about litigation. That's how you're doing it.
I'm not.
If you were,
I talked to them and I never read the whole contract. They know what the
you're
decree
not
says.
supposed to listen to those
Who's
things.
that? You know what freedom of speech is in America?
Yes, the court. If you're here for the kids, can I come to the kids?
You know what freedom of speech is in
Can I
America?
come to the kids? George, the court told us not to. Do you think it's for the kids?
I object. I don't see the reason for the recording. I mean, we're talking about free speech in America and whether I can talk to my sons about something that's relevant to their lives. And the fact that she began the litigation by saying child preference, I mean, I don't see the relevance.
The objection's overruled. It goes to co-parenting between the parents.
Exactly.
Freedom of speech and freedom of community. Just like you can go free and nobody can play your sentence, the same thing applies. You can't tell me not to talk to my kids. I'm their dad. I'm their father.
You think it's mentally safe for the kids to be talking about these things to the court?
You think it's mentally safe to have this?
I said, you
Wait, I'm going to let you talk to them. Just give me a second. Do you think it's mentally okay for you to be doing everything you're doing?
what did I do?
So we can benefit over nothing, and then you turn out to be a liar in the whole court.
Really?
Yeah, really.
I'm lying?
Roll tide. Roll tide.
I have to remember that.
You can prove anything. You can have a part of a part, yeah.
I did not. I think that you were involved with a
No. You don't have to. I took the whole video. I took the whole video of the whole court.
And you showed it
They got it. That's why they're not okay with more meetings. Your Honor, thus far, it's been established in this recording that Mr. Rivas is discussing litigation.
Objection.
Meeting, and I'm not done, sir. Okay, I'm not done. What's the objection?
The objection is, you're admitting something that says that I'm speaking to my children, yet I didn't speak to them. They witnessed a recording of their mom lying in court, and they witnessed the whole court hearing. So how is that speaking to them about it when I'm just letting them make up their own mind and watching what their mom's doing?
Okay, this is all both Mr. Lee's statement and Mr. Conover's statement and make your argument at this point.
Mr. Conacher can't make statements. He's an attorney. He can only represent his client.
Do you have any other parts of the recording you're going to play, Mr. Conover?
I do, Your Honor.
If I may be evidence, but you shouldn't make comments after playing part of the recording.
I will refrain from making comments.
I will be holding court.
I'm fine. Who isn't in writing? I told them. I didn't even know situation. You have been
Yeah,
through.
they were calling. They were calling. I got the whole thing of it.
Yeah, I didn't lie for it.
Okay, then why did?
Objection. Why is he jumping around if we're trying to hear the court recording?
You can probably just play portions and you can require the rest of it to be played after we finish.
Is he gonna, does he have a transcript of it so we can review it or anything?
I don't know if he has a transcript or not. Next thing you know, you know. What are we doing here?
They're not supposed to know. I'm trying to read your story.
I know situations, you just try to get me to testify in court. Got my first word to a judge where he wanted to live it. You get repercussions of it. So don't feel like if you want to argue or say whatever you can, say you can, just go ahead. Okay. It's okay. You're not doing anything wrong. Hi. This is the best stuff I do. If you do it to yourself, I will tell you. If you want to understand the wrong, this is the way to do it. I'm telling you. You might want to see it. This is the wrong thing. If you want but if you guys want to go wherever you can, I'm not holding you. You're doing it. I'm telling them what happened. So the truth is what happened. There's no way to do that to protect that. What are you doing? They don't want to go. I'm okay with it. I'm not making you say. If you want to go, I think that's not going to go. I know they do.
Your Honor, at this time, I'll go ahead and move to for the introduction of T4 and the evidence at this point.
I object because we still don't know the relevance or the reason why this is being admitted. I still don't know the nature and cause for the lawsuit.
Sections overruled was admitted. Mr. Rivas, do you want to have the other parts of the recording played?
I want to have the rest of that played.
You're on mute.
I'd like to have the rest of that recording played, just so that we can establish what it all said and the basis of.
Put it back up, Mr. Conover.
Yes, of course.
We'll start from the beginning.
Your Honor, just a question. Will this be on his time or my time? So we'll be here.
He's asking you to play, whatever he's asking you to play is on your time.
Okay. I can start from the beginning. Mr. Rivas, can you tell me where to go?
So yes, Mr. Levis, you can tell him to stop or tell him to skip.
He can pick up right where he left off a second ago. That's when my sons actually choose not to go with their mom. So.
Okay, let's go back to that point. I think it was about 24 minutes, 24:30.
24:30.
Okay, go ahead. It was scared to moment for that.
Everybody else is everybody. High risk people.
I gotta use some math.
Does he use math bias? Different kind of math. Does he use a math? You can.
That mature right there. That is the story. That's great. I'm not doing anything. This is the consequences of when someone does something.
So this is
I don't agree with it. I try to go through the courts, and you think we're still doing the right thing. They heard the court, they saw everything, and they don't agree with what you did. They're showing you that they don't agree with what you're doing. They're showing you where it's from. They read it and saw all the paperwork in the court case. Look at what you're doing.
Our life is so peaceful until you come back and take all this and melt it up.
Do you remember when you were correcting me about the information I was giving them? Do you remember when you let me walk away during my week whenever they and let them suffer through that? Their dad went to go pick them up. You put the cops on me.
Okay, you had
You did
to
this.
come.
You did this. Look at you. You get so calm whenever you're ready to argue.
No.
Don't do this. This is your mom making a big deal. Remember I told you to do this? Remember I told you this is not gonna help her. You want to murder stuff, go with it. But if you don't want to, you don't think that
Bring it, I can.
don't listen. It's okay.
No.
I'll deal with it.
Stop talking like your pocket, please. I did what did you want? I didn't want to shut up. I said let him talk. Let him talk. Let him talk.
No one's screaming. Stop screaming. Remember, mom. Do you want to go with it? You think yes or no?
Something would be, and would be able to listen to me.
Yes.
Take it into consideration.
Yes.
Try to see if she'll actually listen. Don't let her trick you. Don't.
Stop. Trick what?
Let's go outside and talk about it.
No, I'm not
Do you see
going
that? Do you see that? No, she doesn't
The
want
last
to.
time I talked to you, it was like doing that. It was like you just yelling at me. You don't let me
Did I
talk.
yell at her? Did I yell at her? You were sitting right there, Ivy. Did you see how she blind?
I'm not the
Do you see that? That's what you're supposed to do. And if you're with about this is not that. You're not doing something bad. You're showing her why it's wrong. She needs to see that. She needs to see how she's hurt you. Or how she could hurt you. She needs to see it. You should not do it. Look, I'm not telling you to stay. I'm not telling you to go. I'm telling you what you know already. There's no other way to do it. And she genuinely not listening.
I just want to go.
If you want to go, you want to go.
Please,
That's fine.
please.
Have the conversation and let her answer for whatever you got questions. If she doesn't listen, then you'll talk and I'll let you go. But Ruben doesn't want to go anyway.
I want, it's my week with Ruben.
Ruben doesn't want to go.
It's my week with Ruben.
Ruben doesn't want to go. You heard him.
And George, you can't keep him from me.
I'm not.
You can't, yes, you're not allowing him to come with me.
I said, do you want to go with your mom? He said no, and he went inside.
You know, legally, they don't have a choice either.
That's what I said to the cop. He said, this is a civil matter, and he said, get away, go to the
This is my
house, or
week.
you're going to get arrested. he doesn't have to get up there. You can go if you want. I'm not holding you there. I'm just letting you see where she goes. I'm pretty sure she's gonna tell 911 again. Did I do anything wrong? No.
You let Ruben come with me. Let Ruben come.
It's okay. He said he doesn't want to go.
Let me fucking Ruben by myself. Whenever you're wrong, please.
I'm a better influence.
No, because you keep talking over everybody. You're talking. I already said, you let me talk to the boys, you won't let me say anything.
Just here, you just let it go.
Let me talk to Ruben.
Okay. Okay, Ruben. Okay, Ruben. You said I'm putting up with stuff. You don't want to get this thing. You don't want to yell. You don't want to cry.
If you allow them to come with you, this has been no issue.
I'm not stopping them. They didn't want to go. They don't want to go.
You're doing this in retaliation of litigation, yes.
You did all this. How come you didn't take my rights today? How come you didn't say any of your damn things? How come you didn't say
If I You disappeared. You weren't involved. You weren't involved. You weren't involved. If you demanded they come with you right now.
You never was, though. You could come with me. You can come with me.
Please, Ruben, I don't want to be connected to your private. I'm begging you.
You can talk to him. You can hear me. You can talk to him.
Ruben, I'm begging you, please.
How come you don't want to talk to him? You're and they got some questions. Yeah, I can't talk to you about it. How come you don't talk to him?
Because I'm following the law.
There is no law. You have a contract. Understand
The
that.
court told me you cannot talk.
The court has a contract with you. You have a contract with the court.
I think can I talk to you, please?
They're waiting. Talk to him.
Stop. I need a Ruben, please.
I literally stood right in front of you guys. You stood right next to the same way that I'm doing right now, and you did not let me just not talk to them. All I'm saying is, talk to them. Talk to them.
Ruben, please. Please. Ruben, I'm begging you. I just want to please. Please, Ruben.
I think that you can stop the recording. I've pretty much demonstrated how the children, my sons didn't choose to go with her, and they were simply asking their mom why she's doing everything she's doing. So that's why they didn't go with her. And then she came to my home and started a scene in my front yard, screaming and yelling, and that's, typical of what she does.
Okay. Mr. Conacher, we're back with you. It's your witness. It's your question at this point. Thank you, Your Honor. Now, Ms. Bell, because of what was said in the recording that was played for the court, what fears do you have with respect to
Objection. That's a leading question.
Just saying because of the predicate to it makes it lead. Okay. Ma'am, did you hear the recording that was played for the court? And do you have any current fears?
Objection. That's leading.
What's the name? Okay. What concerns, if any, do you, actually, I'll ask it that way. Do you have any concerns with the children's present environment or no?
Objection. How, that's leading too.
So it ended.
Yes, I do.
What concerns are those, ma'am?
He's pretty much trying to paint me as the bad person against my kids, and he's not
Objection.
allowing me.
What's the objection?
That statement is false, and in the recording you hear her talk bad about me, so I don't understand how that's relevant or it's a truthful statement.
Okay, proof is not an objection in and of itself. The court considers all the evidence and weighs it as to credibility.
The credibility is not there due to the fact that she's been, she has at this point lied on the stand under oath.
I understand, that's an argument, sir, but not an objection. Next question.
How do your children act towards you currently, Ms. Still?
My oldest, he's like, our relationship is pretty normal. In fact, my youngest, he refuses to talk to me, and our relationship just hasn't been moving.
Now, when you say that your relationship with your youngest hasn't been the same, what do you mean by that?
From everything that's been happened and what he's been told, he pretty much views me as some sort of bad person with bad intentions.
Now, between the start of this case and today,
Objection, that's hearsay at this point. If she's testifying to what he feels, it's hearsay. That's not admissible.
Ma'am, between the start of this case and today, how has Ruben changed?
He's pretty much done a whole 180. He's not the happy person he once was. He was once an A honor student. His grades have dropped.
Objection, she's testifying and she doesn't have proof of this. How do we verify this statement?
I have sent paperwork and stuff too, but
How long is this type of grade to not go any further than that?
You were answering the question of how has Ruben changed when you had mentioned grades.
yes, and his relationship with his brother, myself,
Objection.
and
Objection?
The relevance of the grade.
Overruled.
Please finish answering stuff.
and his childhood friends and stuff. His relationship with them has pretty much been non-existent.
That would be a hearsay statement.
Same comment for the president.
Okay. Ma'am, with respect to the recording that was presented to the court, is that an isolated incident between you and Mr. Olivas, or no?
No.
Have there been other interactions like that between you and Mr. Olivas since that recording?
Yes.
Have you been able to have possession of both children consistently since December of 2020, or no?
No.
Now, ma'am, you have in front of you what's been marked for identification as P5 and P6.
Okay, fine. Yes.
Do you recognize those documents?
Yes.
Would those documents assist you in testifying as to how often you've had possession of Ivan and Ruben for this year?
Yes.
Objection, relevance.
Overruled. Do those documents reasonably depict your possession time with Ivan and Ruben?
Yes.
Now, is that for the time, what time period are those documents for?
This is from January to March.
Objection. How can we verify the validity of those documents? Who can certify them?
Objection's overruled.
And, ma'am, did you create these documents?
Yes.
Okay. Your Honor, this one has moved to admit P5 and P6.
This would be hearsay evidence if she created them.
I'll admit them for a summary of her testimony, not for the truth of the matter case.
Now, I'm going to show you what's been admitted as P5. Can you see this on your screen?
Yes.
Now, looking at P5, ma'am, is this exhibit showing your time with Ivan for January, February, and March of 2021?
Yes.
Okay, so did you have possession of Ivan in the month of January?
Yes, I did.
Just so the court can follow along, what do the highlighted portions of this document mean?
My week.
Your week, okay.
Mhm.
And looking in February, how long did you have Ivan?
I had him continuously until the 18th.
So is that from February 1st until February 18th?
Yes, in February.
Okay.
Objection. The statements on the document itself are hearsay, and she initiated the picking up the child from my house to begin with, so she interrupted my week.
Okay. The certain testimony you can put on, as far as the statements on the document, I've admitted it as a summary of her testimony. They are not admitted as documents and proofs of the matter of assurance.
Man, looking in March of 2021 with respect to Ivan, when did you have possession of Ivan?
I had him in March the 1st through the 4th, and then the 12th through afternoon of 19th.
And now I'm going to show you what's been admitted as P6. Do you see this on your screen?
Yes,
Is P6 with respect to Ruben?
yes,
Did you have possession of Ruben in January of 2021?
no,
Did you have possession of Ruben in February of 2021?
yes.
How often did you have, how many days did you have Ruben in February of 2021?
He called me on Wednesday to time to pick him up and...
Objection. That's hearsay evidence.
Okay.
Okay, don't say what your child said now, because how many days did you have possession of Ruben in February 2021?
I picked him up on the 10th and he left on the 19th.
And
Objection. The witness is testifying as to when she picked up and dropped off, but it's not clarifying whether she interrupted my weeks on those occasions or not, and withheld Ivan the whole time, so.
Objections overruled.
Man, for March of 2021, how often did you have Ruben?
I didn't have him that way.
What about for February? Oh, no, I'm sorry. What about for April of 2021?
I had him for 1 week.
Okay. Have you asked Mr. Olivas throughout this year to have time with your children, or no?
Yes,
Objection. Can she prove that she actually spoke to me in written form and told me about what she's talking about, or is she just saying that she's talked to me?
Right now, it's just testimony. The objections overruled.
Ma'am, have you asked Mr. Olivas throughout this year to have time with your children?
yes.
And what has been his response if you had to summarize it?
They don't want to go with you.
And in your opinion, have your children changed?
Objection. Why are we talking about opinions? That would be hearsay.
Overruled.
Ma'am, in your opinion, have your children changed in their demeanor in any way since the last hearing in December of 2020?
Yes,
Do they need counseling in your opinion?
yes.
And what makes you believe that the children presently need counseling?
Objection. How is she making a determination on counseling when she has no credentials for that?
To a limited extent, I'll sustain that. It depends on what her answer is. I think she can give a certain degree of an answer as a lay witness. Certainly she cannot give an expert opinion.
Ma'am, you can answer to that question as to why you believe that the children presently need counseling.
Just because they've been distant, and the relationship with myself and each other and stuff have been difficult during this time, and I want to help them repair that, and just mentally and emotionally, I want to help them heal.
Objection. How is she say? What is the cause for her saying that they need healing when she began this lawsuit to begin with?
You can ask her about that when it's your turn.
Ma'am, when you say that you want to repair the relationship,
This is leading a question. That question is leading.
Overruled refers to testimony that she just made.
when you say that you want to repair the relationship with the children, what do you mean specifically when you say repair?
Just want them to be able to trust me again and rebuild that relationship that we once had before all of this.
Now, ma'am, prior to this present case being filed, how long have the children been in your care?
Objection, she was withholding my sons. That's not a truthful statement.
I've been taking care of them primarily since about late September 2013. They've been living with me primarily.
Objection, can she verify that's fact with any kind of evidence?
Overruled. And, ma'am, how are the children currently doing in school?
My oldest, he's been doing well. But my youngest, he's had up to date about 9 or 10 unexcused absences.
How do you know? I'm sorry, please.
Each class.
And then I mentioned before his grades, and the reason I know is we have a online platform that the school allows us to check grades and attendance, and they also call us to let them know when the kids miss class.
Now, ma'am, has Mr. Olivas either directly or indirectly caused you to lose time with your children this year, or no?
Objection, she's withholding my sons, or has been, and I've submitted evidence on that part. And so when she says that I've caused her to lose time, how is that an admissible fact?
Objections overruled. You'll have your chance to go into that, Mr. Olivas.
Ma'am, I'll ask you again, has Mr. Olivas either directly or indirectly caused you to lose time with your children this year, or no?
Yes.
Are you asking for makeup time with both of your children?
Yes.
Are you asking for the court to order Mr. Olivas to ensure that the children are in their possession?
Objection, he's leading the witness.
What are you asking the court to do with respect to the current possession of the children?
Objection, there's a custody agreement with the court already, and she's violated and breached it.
Objections overruled.
You can answer my question.
I would like to have them primarily as before.
Okay. And what are you asking the court to do with respect to ensuring the child custody evaluation continues?
Objection, what is the child custody predicated on? What is the nature and cause for that? I still don't know that. When was there a hearing on deciding if my sons needed an evaluation to begin with? I wasn't part of that discussion, and that was part of the attorney's ex parte communication with the associate judge.
Objections overruled. The court made that ruling at a contested hearing.
When was that hearing? I wasn't present.
Hearing in December, you were here, and that was part of my ruling. Next question.
Ma'am, I was asking you, with respect to the child custody evaluation, what would you ask this court to do?
To allow me to have my kids when they need to participate in the evaluation.
And is the current week-on, week-off possession schedule working or not?
No.
Objection, she's the one that violated the week-on, week-off schedule and withhold my sons. How is that a truthful statement?
Objections overruled.
What are you asking this court to do with respect to modifying that current possession rule?
For me to have primarily custody of the children.
Do you want Mr. Olivas to have more or less time with the children?
Right.
And,
Objection, how is this co-parenting when she's blatantly wanting the other parent to not spend time with his son? She has an agreement with the court for co-parenting, and she has yet to demonstrate that she ever co-parents.
As an evidentiary objection, it's overruled.
Ms. Doe, with respect to ensuring that Mr. Olivas complies with whatever the court orders.
Objection, that's leading, and she's the one that breached the agreement.
I'm bringing the question to the rule. Ms. Doe, with respect to ensuring that Mr. Olivas complies with what the court orders today, what would you ask the court to do
Attorneys testifying in regard to whether I have complied or not complied.
Overruled, Mr. Court. With respect to ensuring that Mr. Olivas complies with what the court orders today, what would you ask the court to do with respect to any future hearings?
That we have, we meet again to ensure that he does what is asked.
Calls for legal
It's
determination.
a follow-up to a follow-up hearing.
What was the objection, Mr. Leader?
He's asking her to make a legal determination, in her question.
I'll allow it in a general sense, but not for extended legal relief.
I have no further questions at this time, Your Honor. I'll ask the witness.
Okay, Mr. Leader, you can ask her questions now if you wish to do so.
Rhonda, have the boys attempted to talk to you about what's going on and how they feel about it?
Objection, I call upon her to rely on hearsay, Your Honor.
Take the question one more time.
Have the boys talked to you about what's going on? This is just a yes or no.
Yes.
Have they expressed whether they agree or disagree to you? Yes or no?
Calling her to rely on hearsay, Your Honor.
Same.
At any point during this entire lawsuit, have you talked to me or let me know in a sort of notification why it is that you sued me?
I tried talking to you many times before I even did anything.
I'll rephrase the question. Have you noticed me of the reason for this lawsuit in written form of any type?
Objection, relevant as to why we're here today, Your Honor.
Overruled.
Not in written form, no.
Have you and your attorney at any point had a conference to discuss the nature and cause of this lawsuit with me?
Objection, I call for her to reveal privileged attorney-client communications, Your Honor.
I think he said it with him.
Yes. Yes.
Overruled.
With you, no.
Have you and your attorney reached out to me at any point to talk to me at all in any sort of conference as to this lawsuit or give me, it's a yes or no?
No.
Has at any point during this entire lawsuit, anyone reached out to me to talk about the lawsuit?
I've tried talking to you a couple of times.
When we had this meeting, were you able to keep calm and have a discussion like two co-parenting parents?
I tried.
I will rephrase the question. During the conferences that me and you have had, and you have shown evidence of it yourself, were you able to keep calm and talk to me like an adult co-parenting?
What is it? Can I answer, Your Honor?
Overruled.
Yes.
Based on the recordings that you've played in the court, do you call that being calm?
It was an emotional time because that's the first time.
I'm
the
sorry,
kids have
it's a yes or no. In the recordings that you've played for the court, do you call that being calm and co-parenting?
I'm going to object. That's a sort of vague question, number one, Your Honor, and any response she gives is
The relevance of it is based on her own evidence.
Objection's overruled. You can ask the court.
Do you call, based on your evidence, Rhonda, that you submitted while talking to me in these calls or in these moments in front of the children or when it's just you and me, do you call that being calm and co-parenting?
That was an isolated situation, though. I mean,
It's a yes or no, I'm sorry. Do you call that being calm or no?
that was an emotional moment.
Again, I'm sorry. It's a yes or no. Do you call that yes or no, calm?
It's yes or no, Grant, you say it's yes or no answer.
Yes.
If that's what you call being calm and co-parenting, how do you expect me to work with you and talk to you if you can't keep calm?
Objection, I'll sort of speculate as to what she's.
It's based on her own behavior.
Section's overruled.
I tried to talk to you on multiple occasions, but as the recording pointed out, I can't really get a say in anything. I get over talk, or like I'm trying to talk and you won't let me talk, and it's just aggressive. And in that moment too, like that was an emotional moment. I didn't expect my kids to not want to come home in the whole situation. So I was trying to be as calm as I could at that moment, but I was emotional because I didn't think that I would ever have to hear that or see that. So yes, that is as calm as I could be at the same time in an emotional state, yes. But I have to be calmly in the past. But it's hard when I can't say what I have to say. And I can't, and if I don't agree with you, then that's just, you just keep over.
If that's as calm as you can get to, if that's as calm as you can be during a conversation with me, how am I supposed to approach any conversation with you?
That was an isolated situation though. I tried, like I said, I didn't show up there that day thinking that my kids were gonna feel that way towards me or the situation. So yes, I was emotional at that moment, but like I said, I've tried talking to you calmly before in the past, but it's just a real struggle talking to you sometimes. When I get over talk, I can't express my thoughts, and then you just keep pushing me about litigation and things like that. It's very difficult, but no, that is not always how we speak to each other.
How many voice clips or audio clips or video clips have you submitted as evidence where you stayed calm and managed to talk to me and co-parent?
I don't know how many exactly, but we had in the previous.
Where you stayed calm and you managed to talk to me and co-parent?
We have.
How many video clips or audio clips of that do you have evidence for?
There is not one in evidence, but we've had conversations.
Whenever you talk about me to my sons in front of me, in what sort of terms do you refer to me?
What do you mean?
Well, you've been known to, based on your audio clips, say that I am not a good influence, or that I am part of a cartel, or that I don't have their interest in mind, and that I'm not doing what I'm supposed to. Do all these things sound familiar that you have said?
No.
Objection. The audio clips of her own testimony prove that all those derogatory terms are spoken and said in front of my son that she herself has submitted.
Okay, that's in the nature of an argument as opposed to an evidentiary objection.
Okay. Rhonda, do you ever promote the relationship between my sons and I to my sons? Do you tell them to speak to me? Do you tell them to spend time with me?
Yes, whenever it's your week, I don't get involved. I let them go, no problem, no issues. I never tell them anything about not going with you or anything like that.
Have you picked them up during my week?
Yes, when they say you allow them to.
Do you interfere with my time with my sons at any point? Whether they initiate it or otherwise, do you come and interfere with my time?
I only
It's a yes or no.
I don't interfere with their time. They were given permission by you to come home.
Would you consider you picking them up from my house in the middle of my week interfering with my week?
But you relinquished that. You allow them to come home.
It's a yes or no.
No, I don't interfere.
If you don't consider picking them up on my week as interference, then what is interference?
When interfering is me going over there and forcing them to come with me, or not letting them go on your week every single time that I pick them up early, or I even ask to stay, they were given permission through you. I've never told them they can't go, don't go, or I'm gonna pick you up early, or anything like that. Each time they were given permission for you to come home early or to stay. So no, I don't believe that I'm interfering with your week.
Do you have any proof of communication between you and I where you asked me if it's okay to come pick them up? Between you and me?
I do.
Do you have evidence of that you can prove?
Not submitted today, no.
Does your attorney have any evidence of you communicating with me to clarify or to make sure that it's okay to come pick them up on my week?
Objection, that's getting into privileged attorney-client information, Your Honor.
The relevance is based on the evidence, and whether she promotes my son spending time with me or not is my point of what I'm trying to prove.
The question that
Communication itself, the communication between Ms. Doe and her attorney is privileged. But if she has a recording she gave to her attorney, the recording is not privileged. So you can answer the question about whether there is any actual recording.
I want to know that.
Okay, so what was the question, sir?
Is there a recording made where you promote the spending time with my sons?
Promote. Okay, the question. Okay, sorry. Can you repeat that?
You
I
have
don't understand the question.
you have a lot of evidence for that we argue or so, but do you have any evidence where you promote the relationship between myself and my sons at all?
Promoting, like encouraging?
Correct. As a co-parent would, do you have any evidence where you promote my son's relationship with me?
I don't understand what. Other than me not interfering with your pickup and like things like that, no, I don't have any. Like, I don't know what you mean by any evidence promoting your relationship with them. I don't.
Do you have any evidence where we all just get along and no one's arguing with anyone? It's just a good time.
A good time.
Yes,
I
like it
mean,
should be. Normal, just a normal day where we all get along and don't argue.
I mean, we don't. As for me and yourself, we don't interact.
In front of the
Other
kids.
than what? I don't understand.
I'll rephrase the question.
Me.
Is there do you have anything to show where we are getting along? You have a lot of evidence where we don't get along. But do you have any where we just talk and it's normal and you just talk to me like a normal person?
As a reason, no.
At all?
Everything was in the past, yes.
How
But
often?
as of recent, no, because each time you want to talk about the litigation, you confront me about all those things, so, no.
How often would you say that you promote the relationship between myself and my sons to them?
What do you mean?
Well, when you're co-parenting, you're supposed to make sure and not, dissuade the children from speaking to the other parent, and you're supposed to work with the other parent and communicate normally. So I'm just asking for how often do you do that?
I mean, I have never interfered with them calling you or texting you or anything. If they want to call and communicate with you, then they can, but I never stopped and told them they can. And like whenever they come back, oh, what did you do? Things like that. But and just see how their week was and stuff, but nothing like, I mean, I don't know how or what you're expecting.
What would you say as far as my relationship with my sons and how it should be? What would you consider a good relationship between me and my sons?
Well, being there for them emotionally, mentally, education, physically, things of that nature, a healthy relationship.
What have you done to make sure that I spend the right kind of time with my sons? Do you encourage me spending time with my sons, or do you not like it when I spend time with my sons?
When it's your time to go, I tell the boys, it's your week with your dad. And I never stop them, I never say anything. If get ready, it's almost 6 o'clock, they get their stuff. I even help put their clothes and stuff together for them to go. I never stop or discourage it in any way, shape, or form.
In what way, or what is the reason for you to, in your petition, demand that my time with my sons be diminished and that I be treated like a criminal where I don't have joint custody?
Well, since 2013, since Ivan started school, the boys have been living with me primarily. I've taken care of them since then. You'd only have them every other weekend. And the two and a half years or so that you weren't involved as well. And then now
you've testified that you don't have any proof for the 2 years of the disappearance. And so my question is simple. What is the reason, the nature of why you demand that I spend less time with my sons if you're supposed to be co-parenting?
Because if we look back at the record of everything that's going on, I don't think it's healthy this year as far as education goes, mentally, emotionally, it's not healthy for the children.
Who initiated the lawsuit?
I did.
On what basis, and who did you talk to about testifying in court?
What basis? Because I've been, like I just previously stated, I've been taking care of the boys. You weren't involved and you came back and threatened me. So as a protection for myself and the boys, I filed an attorney.
We spoke about the threats that you speak of, and we clarified last hearing that when you say threats, you talk about me saying that for identity theft or enforcement of the decree, I would sue you. But has there, and you also testified to the fact that I've never physically or otherwise threatened you. So what is the reason for you saying that I'm a bad influence to my sons? Do you have any evidence of that?
Well, you're pretty much trying to turn them against me, alienating me.
Do you have evidence of that?
I mean, I would love to have, that's also why I would love to have Ruben talk to the social workers.
So if you've initiated the lawsuit and you spoke to Ivan about testifying in court, then who started the litigation speak with my sons?
The judge asked to interview the kid.
Before the lawsuit was filed, since you didn't speak to me, would you consider you speaking to Ivan about testifying the one that initiated speaking to the children about litigation?
I didn't speak to. Okay, sorry, repeat that again.
In your petition originally, you say that Ivan is wanting to testify in court as to preference. So if Ivan didn't know the divorce decree, who spoke to him about giving testimony in a court hearing?
He wasn't gonna be testified though. He's not in the court to testify. He was ordered by the judge to be interviewed.
In your paper served to me, you mentioned that he would testify in court based on child preference. So how did he know he could do that?
Well, if it was my attorney his age, but I never coerced him or anything to what he said. That's why he was interviewed by the social worker.
So then who talked to Ivan about testifying to begin with? How did he find out he could testify?
He's been testifying.
Is
I never said he was testifying.
your petition that I was served for temporary orders and child preference states in it that he would testify in court with the judge? Who told Ivan that he could do that?
I never told him that he was going to be testifying in court. When the judge ordered that he get interviewed, I told them, okay, so they're going to want to talk to you, et cetera, et cetera. And that,
So you admit that you spoke to Ivan about testifying?
I never told him he was testifying. I said, you're going to be interviewed by someone that the judge asked for him to talk to. That's not testifying. I don't believe, Judge, correct me if I'm wrong, I don't think that testifies, right? Like, the judge ordered that he speak to someone. I told the boy, okay, just speak to this person. What was that?
You can ask me a question.
Okay, sorry. Right, but that's the extent. I don't know if the judge is gonna ask Ivan to stand up and witness. I simply told them that the judge wanted to talk to them and this is the person that did, and that was it.
So your paperwork says that Ivan would testify in court, and you say that you didn't speak to him. So is your petition based on child preference, or is it based on what you want?
It's not what I want. It's the best interest of the kids. And I do feel like with them being with me is the best interest of the kid.
So you don't promote a relationship with their father then?
I do. Just because I'm requesting primary custody doesn't mean I'm taking you out of the equation. I would never do that.
Based on what are you asking for primary? On what did I do in order for me not to have joint custody as we agreed originally?
Like I said, again, I've been taking care of them all these years, primarily on my own. I feel like emotionally it's not safe just for everything to, and we've seen evidence of it this year alone that it is not healthy for the boys.
If you say that I disappeared for years at a time, why did it take you this long to file a lawsuit instead of when I disappeared supposedly?
Because I don't want any drama. I don't want anything.
Whatever.
If you don't want any drama, then why do you make such a scene whenever you speak to me if you don't want any drama?
Hold on for a second. Mr. Levis, you have 5 minutes left. Mr. Conover, 5:28.
Final question for Rhonda. If in every one of your statements you say that you want less time with me and you have the best interest of the children in mind, at what point in time did you discuss the best interest of the children with me in order to come to this conclusion? Formally, or let me know in a written notice, or something that can be proven that you spoke to me about this.
I spoke to you on multiple occasions, and even I know you have a problem with it, but we did have a notarized letter stating that you agreed that that we were going to amend the decree to reflect what was going on.
Are you referring to the fraudulent signature letter that is not mine and your attorney said that he did not submit into evidence? Is that the letter you're referring to?
It is not fraudulent, but if you wanted to into the penalty, I will get it and submit it.
Well,
I'd
like to have the attorney at this point, whether he wants to admit that signature or not knowing that it's not my signature.
Well, he didn't have to offer evidence until he wishes to do so,
Well, the plaintiff is Rhonda Doe, and she wants to admit it into evidence, so I'd like for it to be admitted if that's the case. And if Mr. Conacher is okay with that fraudulent signature being admitted, I'd love for it to be admitted.
Is this an exhibit? Is it labeled as an exhibit?
Oh,
So he doesn't want to admit it, or he does?
I mean, it's up to him when it's past his term, if he wants to offer something.
Well, I'm asking him a direct question at this point. Can he answer that?
Witness crosstalk between the person asking the questions and the other attorney is not appropriate.
Okay. Well, in closing, Rhonda, if you are doing this in the best interest of the children, at what point in time did you take me into account in your decision of the best interest of the children? And how do you not, or how, that's it. When did you take me into account in this decision?
I tried talking to you multiple times, and at one point you even told me if I dropped the lawsuit,
That's hearsay.
everything.
Overruled.
You even stated to me that if I drop the lawsuit, you will let everything stay the way it was, which means I will have to voice primarily. You stated that.
We have an agreement, and at this point I'm done with asking her questions, since she's, you know.
Mr. Confer, questions?
No questions, Your Honor. I'd like to move and argue my motion to compel and put on evidence for attorney's fees, Your Honor.
You may proceed in that respect.
Okay. Your Honor, on January the 19th of 2021, I electronically served on Mr. Olivas' discovery.
Objection.
Objection?
He's been in default since the beginning. I asked for proof of claim from the beginning when I answered the lawsuit, and no one's given that to me.
Objections overruled.
Okay. Those discovery requests included requests for disclosures, requests for production, printed interrogatories, and requests for admission. Your Honor, I move to admit P2 in evidence.
I object to the admission of that because I still don't know the nature and cause of the lawsuit, and Mr. Conacher has not given me that. So how could I admit to anything if I don't even know the nature and cause of the lawsuit? What is the probable cause for me to disclose anything? What's his standing to sue me under this temporary orders hearing for modification without taking into account that he's breaching a court order by doing so?
Objections overruled and submitted.
Your Honor, the responses to those discovery requests, they were due on February the 18th of 2021. I sent a demand letter to Mr. Olivas on March the 30th of 2021, wherein I requested that he respond to the discovery request with information and documents by noon.
Objection. That demand was done with a threat within it. He said, admit to the evidence or I'll be following up with a legal action. That's not a request, that's a threat for a legal action if I didn't do so without any objections, which is what his letter said. Do so without objections or there will be litigation further. So that's not a request, that's a threat.
I'm sorry, Mr. Conacher, where were you at on that?
I was saying that the information and documents, they were requested by noon on April 6th of 2021, where I would file a motion to compel discovery.
Without objections, Conacher, you said request without objections. I couldn't object to anything.
I'll tell you what, I'll move to admit P3, a copy of the demand letter and evidence at this time.
Any objections to the letter coming into evidence?
No, I think it's okay to admit the fact that he threatened me without objections in order for me to admit anything.
Okay, it's admitted.
I filed a motion to compel discovery on April 7th of this year, Your Honor, asking him to provide the answers and the documents. Now, Your Honor, I have received nothing in the way of documents or information from Mr. Olivas. Now, with respect to my motion to compel discovery, I'm also asking that he be prohibited from any discovery of any kind while this case is pending.
Objection.
I'm also asking Mr. Olivas, go ahead.
How can you object to me asking for discovery if you haven't disclosed the nature and cause? Or answered my discovery, which was proof of claim, and which was filed as a response to your lawsuit.
It's not really an objection, he's making a request, the court has not said it's going to grant it.
May I continue? Yes. I'm also going to ask Mr. Olivas to pay reasonable and necessary attorney's fees to me for having to file a motion to compel discovery.
Objection. The contract is already clear on attorney's fees.
I'll consider your argument that, he can testify.
Your Honor,
I'm sorry, objection. The attorney cannot testify. He's representing a witness, a plaintiff. The attorney cannot testify. That would be hearsay evidence.
You can testify on the issue, please. Go ahead.
Your Honor, as an officer of the court, I'd like to testify on that. My name is Christopher Pfeiffer. I'm an attorney licensed to practice law in the state of Texas. I've been licensed to do so since November of 2012. I'd like to move to the P7, my resume and evidence at this time.
Objection. A resume is hearsay evidence. I'd like to see the license that he holds and the authority to prosecute this case.
Objections overruled. Submitted. Your Honor, the majority of my practice is in the area of family law, and family law has been the majority of my practice since the year 2014. I'm familiar with the facts and circumstances of this case. Ms. Doe retained me to file a modification of the parent-child relationship, and in the course of doing so...
Objection. If he has represented people in family law and is familiar with family law, then how come he's not following procedure, serving me correctly, giving me the time to answer, and filing the motions and discovery requests within the time frame that he served me the lawsuit? He's falling outside of proper procedure and rules of evidence.
Not a legal objection, overruled.
In the course of doing so, Your Honor, my client has incurred attorney's fees. My hourly rate for this matter is $225 an hour. I believe that this is an appropriate hourly rate that is customary for an attorney with my level of experience in the DFW Metroplex. I'm asking the court to award attorney's fees against Mr. Olivas for two reasons. Number one, it was necessary to seek court intervention with respect to...
Objection. What was the necessity? The nature and cause hasn't been disclosed.
Objections overruled.
Number one, it's necessary to seek court intervention with respect to Mr. Olivas' failure to answer any of my discovery requests. I'm asking the court to award attorney's fees in connection with that. I believe an award of $500 is reasonable and necessary in a situation like this. Number two, I'm asking for the court to award attorney's fees in connection with having to file a motion for further temporary orders due to the actual...
Objection. How is temporary orders relevant to a final decree of divorce, which is an agreement that was done with the consent of both adults?
Not a legal objection, Your Honor.
Overruled.
Relevance, it would be the objection. Relevance to the case.
Due to the action of Mr. Olivas with respect to the children in this case, if denial of the children is so and bring...
Objection. He's testifying.
Overruled. It goes to his face that his statements will not be considered facts in the case, but only the reasons that he incurred attorney's fees.
And frankly, he has admitted discussing the litigation and showing the recordings of court proceedings.
Objection. That's a constitutional right. I have the right to free speech.
We're going to stop at this point. Mr. Connor's out of time. Okay. So, Mr. Olivas, at this point, do you want to ask him any questions on the fee issue?
Yes, I'd like to know why he's not following the federal rules of civil procedure.
I'm not following the federal rules. I'm following the Texas rules of civil procedure.
They are in line with the federal rules of civil procedure, are they not? At this point, I'm trying to prove competence.
I don't know how to answer that, Your Honor. I think the Texas rules have to do with what guide a cause of action such as this, which is a modification of the...
What is the cause of action, Mr. Conford?
Modification of the parent-child relationship.
On what basis of probable cause?
It's been material and substantial change. I don't know if you...
Have you proven that? Have you proven that? Do you have any proof of the circumstance of the change? What is it?
Mr. Olivas, if you're going to ask a question, let him answer.
Okay.
I do. You have to be in a position to say that there has been material and substantial change because you failed to answer them.
I'm sorry. At what point in time did you give me the proof of claim that I required when I answered your lawsuit?
I'm not sure what you mean by proof of claim.
Well, if you're familiar with the Texas rules of civil procedure, then when somebody requests a proof of claim, you have to say what your damages are, what is the plaintiff requesting as far as a damage for an action that I have done. What action have I done, and what is your proof of claim?
Please refer to the petition to modify parent-child relationship that you were served with.
Are you referring to the petition that has allegations of cartel, affiliation, drug use, and all of the falsities that Rhonda Doe admitted to in the past hearings under cross-examination?
I'm referring to the petition to modify parent-child relationship that you've received.
So in that petition, are all the allegations there factual? And I may remind you that Rhonda Doe has testified to all this already and admitted to them not being factual or having any evidence to them.
I would suggest that you reread the petition to modify parent-child relationship.
So if you can't answer the nature and cause and give me a proof of claim for the damages that I myself caused, then what's your standing to sue?
Well, it's my client's right to request the ability to modify the parent-child relationship.
If you're familiar with the Texas Rules Civil Procedure and you understand what damages are and what an injury is, then you understand contract law because you deal with family matters, then you understand custody agreements and agreed custody agreements or consensual custody agreements. In what way have I breached my agreement with Rhonda Doe, and what gives you standing to sue me under temporary orders?
I'm not saying you breached any kind of agreement. That's not the nature of the claim. The claim is that there's been a material and substantial change that would necessitate filing a petition to modify the parent-child relationship.
Are you familiar with agreed custody agreements?
Generally, yes.
If you're familiar with them, then what would have to be the cause for, what would be the circumstance substantially changing that would require you for a modification with only one side agreeing?
I'm not sure I understand your question, and further, it's already a deemed admission that there has been a material and substantial change.
If that is the case, at what point in time did you prove your claim?
When you fail to answer the request for admissions, so there are deemed judicial admissions because of your failure to answer them.
I'm sorry, the petition was served to me and it had no charging instrument, no proof of claim, no damages, and when I answered the petition, did I not ask for proof of claim that you never gave me?
I'm really not familiar with what you've asked. Mr. Rivas, you filed many different things under alleging federal rules of civil procedure and sovereign immunity. I'm not sure what you're really referring to.
Sovereign immunity?
Okay, Mr. Levis, you're out of time, so that's the conclusion of the hearing, but I do want to ask Terrence a couple of questions. Mr. Levis, in the past, have you had a good co-parenting relationship with Ms. Doe?
At the beginning, when she was doing her schooling and college, that I was picking up my sons and working with her, and for the first two years or so after the divorce, she worked with me, but soon after she graduated, it became this toxic, argumentative kind of relationship. So I avoided, speaking to her as much as I could.
So you think it hasn't been a good co-parenting relationship since about 2013?
Right around there.
Okay. Ms. Doe, what about you? In your viewpoint, have you had a good co-parenting relationship with Mr.
Since
Rodriguez?
2016.
Well,
2016.
initially right after the divorce, there was still a lot of anger and I mean stuff like that, but eventually we were able to co-parent and and at one point he was unemployed for a while. I took on responsibility for him to find a job.
I'm just asking, how long ago had it turned bad, I suppose, you might
Okay, let me see,
2016.
in 2013, we were able to co-parent. I took the kids on to help them go to school and stuff.
I didn't go to
think the
school.
struggle was maybe, I want to say 2015. Yeah.
I didn't go to school. She went to school.
All right, Dan,
That was in 2015.
I'm going to take the matter for 5 minutes. I'm not announcing any rulings today. If I think that
I haven't enrolled.
input from the children, I'll get with you all on that. Until I rule, the prior decree remains in effect. So everything that's ordered in that decree remains in effect. It is a court order, so y'all have to abide by the pickup drop-off provisions and all the other provisions that are in place at this time until they're modified. And I'm not modifying anything at this time.
have one final item there. If everything in the decree stands as it is, and it should carry over, then at what point do we decide whether the attorney's fees are proper, whether the attorney's fees are proper or not, if she's filing outside the decree to breach it, basically?
Well, I am ruling on the motion for further temporary orders and the motion to compel. The ruling on attorney's fees only addresses those two motions. You all are going to get set for
What
trial.
about Evan and Ruben?
And I'm probably going to talk about setting the funeral later, but I think y'all need to do things. And at final trial, there could be discussion of attorney's fees for the case in general. But that's not for me to decide, that'll be in front of it. So I'm a little bit proud of you, frankly, so we can move this forward.
What about Evan and Ruben?
So at this point, I do have another case and another family waiting for me for me to adjourn. So I will send you all my ruling by email. I don't know if I'll get to you by the end of the week, but next week for sure.
Thank you very much, Connor, for your time.
Good, have a good day.